Morning. We are an elder law practice, and we're gathered this morning to talk about pre-crisis planning for families of a loved one with Alzheimer's. I'm Lori Adamschick. I'm an elder law attorney, and my interest in this stemmed from my parents' last few years and the job I undertook as their primary caregiver years and years ago. Learned a great deal and was overwhelmed by it all. But we're joined by the rest of my team. Tom, you want to take it?
Sure, I'm Tom Rulon. I'm happy to be here. I've been a trust and estates attorney here in Hawaii for the past 4 decades and focus in on estate planning and trust planning. And Kim is our elder care coordinator. Kim, you might introduce yourself.
Hi, I'm Kim Ong. I've been a nurse and a case manager and elder care coordinator for over 20 years. And currently a graduate student in community health nursing at Liberty University. But I have a strong passion for working with seniors, and I hope that you'll be able to see that today through our presentation.
So we're going to talk today about pre-crisis planning. We call it pre-crisis planning for the last chapter. And as you all know, proper preparation in advance gives you the best chance of retaining control in the future. We all know how to prepare for a hurricane, but are we prepared for a medical crisis that renders us incapacitated? We know that if we wait until the last minute, we risk losing control. So during the next 45 minutes, we're going to help you get your ducks all in a row. First of all, what does it mean to be incapacitated? And I want to start out by telling you about a client I had many years ago. Her name was Ruth. This is a true story, but Ruth isn't her real name. I changed her name. But I met her about 15 years ago. She lived in Manoa. She had a daughter and 2 nephews. And I prepared a will, a power of attorney, and a trust for her. Then this is before we started our current process. Pardon me? This was before we started our current process of doing client maintenance programs. And so I did the documents for Ruth, but I hadn't heard from her for, maybe 10 years. Then I got a call from an assisted living facility, and they told me that she was there at assisted living, that her daughter, who was her agent under her power of attorney, could no longer pay the bills because she had become incapacitated herself, and that my client needed a new power of attorney. Now, I hadn't seen her in over 10 years, and they found me by finding my name on some legal documents that they had found in her possessions. So what does it mean to be incapacitated, particularly in the context of dementia? As they told me when I went out to visit Ruth, they told me that she had dementia. Now, that hadn't been officially diagnosed. That was just their assumption because of her behavior. When I talked to her, she didn't know who I was. She didn't remember me. And that's one of the characteristics of moderate memory loss. There was confusion. Lori, you might switch the slide.
Yes.
She was unable to care for herself. She was in a wheelchair, but she could talk. But it appeared to me that because of her memory loss, her confusion, her inability to care for herself, and also their assumption or their diagnosis that she had dementia, that I wasn't going to be able to do much for her. Now, there are 2 types of incapacity that we're going to focus on. The first one. One of them, the first one is the cognitive, and that's mild cognitive impairment. Could be Alzheimer's, could be Lewy body, frontal temporal, or vascular dementia. Ruth appeared to have that, and she also had a physical incapacity and that she was unable to care for herself. She was in a wheelchair and she needed assistance with activities of daily living. One of the things I've learned about cognitive incapacity is if you've seen one, you've seen one. Everybody's different. The way impairment affects a person's mind is different places at different times with different people. Each person is an individual. You can't do stereotypes when you're talking about cognitive incapacity. Now, legal cognitive capacity, that's the ability to understand and appreciate the consequences of your actions and to be able to make rational decisions. Legal cognitive capacity requirements can vary from one document to another. For example, with a will and a trust, there are three basic characteristics in order to determine cognitive capacity for a will and a trust. One is that you know what you own. That's generally, when I meet with a client, do you own a home? Do you have money in the bank? How much do you have for savings? That you know what you own. The second is that you know who the natural objects of your bounty are. How many children do you have? How many grandchildren? Do you have brothers and sisters? And the third is that you have a reason for the distribution plan that you're planning, that there's something rational. Now, I don't have to agree with it, but that you have a plan, that you're being rational. Those are the three things we look at. Do you know what you own? Who are the natural objects of your bounty? And do you have a reason? And those same questions, those same qualifications, pretty much also form determination of whether you have capacity to do a power of attorney. Well, the sooner the planning starts, the more a person with dementia is able to participate. But once cognitive capacity is lost, a person's ability to sign valid legal documents is lost. It did not appear to me that Ruth had legal cognitive capacity. She didn't remember who I was. She seemed confused. She didn't seem to understand what I was saying. She didn't seem to hear me. So I left meeting her, went back to my office with the concept that, well, maybe what we're going to have to do is do a guardianship because her daughter was no longer capable and we were not able to do a new power of attorney for her. Well, what are the documents that you should have? One is a will. If you don't have a will, by the way, the state has a will for you. It's called the law of intestacy. And the legislature got together and decided who they thought most people would want to give their assets to if they died without a will. And so that's the law of intestacy. But a lot of people have their assets held in different forms that bypass the will. For example, a joint tenancy. You might have a will that leaves your estate to one person, or the law of intestacy that leaves it to your children, for example. But if you have a joint tenancy with one of your children or with somebody else, they get it. So a joint tenancy bypasses a will or a law of intestacy. Also, there are payable on death accounts. That's where you have an account with a bank, and you and you have with that account a designated beneficiary. And there are, of course, also beneficiary designations for things like IRAs, life insurance, a pension plan. Those bypass the will. Now, if you don't have a power of attorney, then the court is going to need to appoint a conservator to manage or protect your assets and a guardian to protect your person. That's what I thought we were going to have to do for Ruth, because she didn't have an alternate agent under her power of attorney. And the third document we want to make sure everybody has is a advanced health care directive. An advanced health care directive is a power of attorney for medical care decisions. It's often combined with what's called a living will. It used to be called a living will. That decides what kind of life support you want to have at the end of your life. We're going to talk more about those documents later. But if you don't have an advanced health care directive, then it's up to the family to get together and appoint a surrogate. A surrogate is a decision maker to second guess what kind of care you might want. Well, now, if a person gets into a crisis, a stroke, an accident, determination of incapacity because of dementia. It's like you and your family, and if you're not prepared, it's like you and your family having confusion, uncertainty, panic. It's like being on the freeway. You're late for an appointment, your GPS goes out, and the map's in the trunk. You don't know you don't know which exit to take. We've all been there. And what happens is you enter into what's called the long-term care maze. Lori's going to talk a little bit about that because that's what she went through with when she had to sell her business and go full-time as a caregiver for her parents.
That's correct. I was plunged into the long-term care maze after my mom had a serious stroke, and I brought her home to my house after her period of rehab. I was utterly unprepared for all the decisions I had to make. And even though I had therapists and visiting nurses and part-time caregivers to help me try to keep all the balls in the air, it was still I had a disastrous first month trying to manage all of it on my own. I became extremely ill. Not only did I have to manage my mom's care, but we had a 3-year-old at that time. I had a very successful business, and I was falling apart. And I, like so many people, was basically left with, where do you start? How do you get help? How do you find caregivers? How do you choose a good caregiver? How much should you pay them? No idea. Well, if your loved one has been diagnosed with Alzheimer's or a related dementia, you should consider starting the planning process as early as possible while they're still able to participate in expressing their wishes. This will help the family avoid the anxiety of not knowing where to turn or what to do. Start thinking about who's going to care for them, how long-term care will be paid for, and who will be assigned the role of financial agent under a power of attorney and medical agent under an advanced health care directive to make decisions for them when the time comes that they are not able to make them themselves. To guide you through this planning process and help you understand the options and the advantages and the disadvantages of those options, consider assembling a team of advisors and navigators as early as possible before your loved one becomes incapacitated or suffers a catastrophic health event. Your advisors should include an elder law attorney who can document your loved one's wishes and assist the family with solutions to estate planning, financial, and personal care issues. It should also include an elder care coordinator. This is often a nurse or a social worker who focuses on helping an older adult find the right care from reputable care providers in the community. Now, if you're unfamiliar with this term, elder care coordinator, and wondering what exactly an elder care coordinator does, well, let me introduce you to Kim Ong, our elder care coordinator, who will tell you a few stories that demonstrate how important her role is on your loved one's care team.
Hi, so many of you may not be familiar with what an elder care coordinator does, or you may not have even heard that title before. But basically, an elder care coordinator is able to recognize where a senior is in their life course by implementing coordinated care team strategies and interventions, guided by the client and family's goals in order to achieve and meet their current needs as well as their desired outcomes, and ultimately maintaining those choices. An elder care coordinator is important for all seniors at any stage of life, from age 65 to 105. And we have many of those in the 100-year range. And the seniors fall into 3 distinct categories. One category would be a senior that would have maybe no maybe they are without or minimal chronic illnesses. And that phase is known as a health promotion phase. For instance, the priority for someone in this category would be brain health promotion and education. That is their priority. That encompasses 10 healthy lifestyle dynamics that would then carry them through optimized lifestyle choices, and achieve the longevity that they're looking to have, that they desire. The second category of senior, which may be more what you're familiar with, since you're in the Alzheimer's group, is that a senior who may have chronic multiple illnesses, or in the case of Alzheimer's, they may have early to moderate cognitive disease. So in that situation, an elder care coordinator would be able to carefully monitor their disease progression, and ensure the priority of health, safety, and well-being. This would be where we would monitor them carefully, looking at their level of care, making sure that that meets their care environment. And this may include things like, incorporating home health services, adult day health placement, or other creative options in order to meet all of that client's needs. And of course, the third category of senior would be a senior that is in an acute crisis. And we do encounter these crises quite frequently. This would be somebody, again, in the Alzheimer's realm that may have very late stage disease, or they have some type of advanced cognitive disorder. And their highest priority in this group would be to protect the frail, vulnerable, and high-risk individuals from neglect, abuse, and self-harm or exploitation, because those people are without a voice, as you know. So this may include looking at things, that for the individual that would encompass maybe a hospitalization, maybe they require placement, or supplemental care, palliative care, hospice care, or even end-of-life support, to alleviate care burdens from the family. So I know that's a lot of information, but the elder care coordinator job is quite a large job. And it's something that I do take very seriously, because many times when I receive a call from the families, they're already overwhelmed. They are generally paralyzed by indecision, and they're already in the midst of the crisis. They're unable to move forward, and they have difficulty coping with the circumstances. So it's very important, as the adult children or spouse of someone with an advanced cognitive disease, as to how we can help intervene for the family and for the individual at the same time. So one of the very first things that's being done is that, of course, assessing the client and their environment. And the environment is a lot of times something that would kind of tip the scales into us realizing how maybe the depth and the breadth of the situation could be, because I've walked into environments where there's mass hoarding, or there's, toxic, rodent infestation, or the person may be having self-neglect in a situation where they have anosognosia. They don't even know that anything's wrong, and they're eating black molded food and things like this. So these are very serious situations, of course, that require urgent intervention. So the number one thing that's done is a home health, a health and community-based assessment, and cognitive assessment and screening that's completed. And moving forward from there, then we would incorporate, Lori, on the next slide, we would incorporate looking at, what all the resources are that we could utilize for the family. And that may include, technological things, which of course in this day and age, as we're all in this webinar right now, and even that's changed the face of my practice too, because, performing some of the initial webinars with doing the quality of life assessment in a teleconference meeting. So therefore, when I go to the home, it's a minimized time, and in this current environment of COVID. So we're looking at technological resources. So having seniors with iPads, with abilities to be involved in webinars, and then being able to translate that into recommendations and further interventions that would assist the family in meeting the future care needs. And one important thing to realize is that this is not something that just happens in the beginning of the course of an elder care being involved in your senior's care, but it's actually throughout the life course. So it's really a relationship-based type of care that where friendships are formed and bonds are formed with the caregivers, the families, the individuals, so that we can maintain the support and achieve, maximum and optimized desired outcomes for these clients. And if any of you like, I think after the presentation, we do have a really great, succinct paper that describes the role of the elder care coordinator, so that could always be requested. And that might even give you more insight as to having an elder care coordinator involved in your senior's life.
Am I up?
Yes.
Okay, well, after you've retained your elder care coordinator, and your elder care coordinator has done a baseline assessment and come up with a life care plan for you or for your loved one, the next thing is you want to consider how you're going to pay for the care. Remember Ruth? That's what generated the call from the assisted living to my office 4 years ago. Ruth's daughter was no longer able to pay her bills. The assisted living wanted to know how their bills were going to be paid. Ruth lacked the capacity to pay her own bills, and there was no alternate named under her power of attorney. So they wanted me to come out and talk to her about doing a new power of attorney. Well, I told you about our meeting, and I didn't think that I was able to do anything further for her other than perhaps petition the court for a guardianship. But when I got back to my office, this was about 4 years ago, and we had hired our first elder care coordinator. Her name was Sue. And she said, well, wait a minute, Tom, let me go out and talk to Ruth. Let me talk to her physician. Let me talk to her care providers and see what I can think maybe there's something we can do. And so Sue went out to talk with Ruth. And now to be prepared to pay the bills, you want to get financial guidance from your financial advisor, your elder law attorney, and what you want to do is create kind of a long-term care fund. Now, there are some possible options. The first option, which I always recommend to my clients, is that they have a cash reserve. This could be a joint bank account with a trusted child, or you could name a child as an agent on an account. That's a special card that the bank has. You go to the bank and ask for an agency card, and you can name the child as an agent on the account. And the purpose is to pay bills. And so you may want to have maybe 6 months worth of bill paying possibility, in that cash reserve account. Now, I mentioned using a joint account. If you use a joint account, the child has access even after you die, and that can be helpful in paying for funeral expenses and paying final bills. But you also want to have that accompanied with what we call a joint tenancy intention document. That's a special document that indicates your intention that the child not inherit that money, but that the child use the money for paying bills, and when that's completed, the excess money is to be returned to your estate. The alternative is an agency account, and that terminates at death. And everything then is frozen. And that's part of the problem with the agency account is the family can't get access to the assets to pay for funeral, to pay for final bills, until they get a death certificate. And that could take months. So I often recommend using the joint tenancy account with a supplemental tenancy, joint tenancy intention document. Another way of preparing to pay bills is a reverse mortgage or a home equity line of credit. Now, I went out and got a reverse mortgage for myself. It lies dormant. I haven't drawn on it. I'm not paying any, there's no interest being charged. It's just sitting there, but it's a backup plan. In case I have an emergency, in case I need long-term care, and until other resources can be organized, we can draw on the equity of my home to cover. So it's a backup plan in case of emergency. Another document that might consider is a long-term care insurance. Now, if you have a long-term care insurance policy, be sure you've read it and know when it kicks in. We were hired recently by a client, and one of the first things we did is we took his long-term care insurance policy and reviewed it, and we found that he had missed 2 years worth of coverage for his wife who was incapacitated. That just money that was lost. He had paid premiums, but he didn't use it. So you want to make sure if you have a long-term care insurance policy, you know when it kicks in, and you're prepared to move forward on it, or your family's prepared to move forward on it. And maybe the third kind of document that could be helpful is a parental protection trust. And that's simply if you're still insurable, that's where you have your children might set up a supplemental needs trust for you and put a life insurance policy, put premiums into that trust to purchase a life insurance policy with a long-term care rider. And if you become incapacitated, the rider kicks in, money's then used to provide for your care, for your long-term care, and you're not disqualified for Medicaid because it's in a supplemental needs trust. So that's a special kind of planning that can be done. Now, once you've got your documents, once you've got your plan for prepared for paying for long-term care, you want to make sure that you've got your documents organized. So if your team includes an elder law attorney, your elder law attorney can assist with customizing and updating your legal documents. And we mentioned that legal documents you should have before your power of attorney. The attorney should review that periodically. Make sure that your selection of agents is appropriate, that the agent is stable, that the agent is available, hasn't moved away, that the agent is financially has good financial sense. And you may want to include some enhanced provisions in your power of attorney in case of a disability. For example, you might want to give the agent the authority to sign the annual intent to return home if you're in a nursing home. If the intent to return home is not signed every year, then your home may become a resource and disqualify you for Medicaid. You also might want to give your agent the authority to discharge you from the nursing home and bring you home for your final months in hospice. If you do that, then the lien that was placed on your home is dissolved. And so those are some planning things that can be done if you have a properly drafted power of attorney with enhanced provisions. And of course, with your power of attorney, I think you also want to put in some safeguards, some kind of a way so that the person who is acting under the power of attorney, your agent, you're protected from exploitation, perhaps by having accountings go from the agent to other family members. Well, that's the power of attorney. You also want to have a advanced healthcare directive, but in addition to the advanced healthcare directive, we suggest having a supplemental form, something like we have a document called Your Way, which asks a number of questions. There's also a quality of life statement that we provide our clients, and some of you may have heard of the 5 Wishes document, but these are supplemental documents in which you can be more specific with your agent about the kind of care you want in the end of life. And so we want to make sure that we go a little bit more in depth than just having the advanced healthcare directive. And then, of course, using a revocable trust is often advisable in order to manage your assets if you become incapacitated. And that, of course, also has the benefit of avoiding probate. So your attorney for your estate planning should provide an ongoing maintenance program for you. An ongoing maintenance program means regularly monitoring your estate plan and your finances to assure that somebody knows where the assets are and that they can be easily located in the event of a catastrophe, in the event of a crisis. We want to make sure that your trust, if you have one, is properly funded. We oftentimes find assets that are not put into the trust. The client leaves and never gets around to putting them in. Well, a well-maintained maintenance program, the attorney will meet periodically with the client, at least annually and oftentimes more frequently, to make sure that all the assets that are supposed to go into the trust are in fact funded into the trust. We want to make sure that an emergency funds are in place. And we want to make sure that all legal documents are kept up to date as circumstances change. So the agent under the power of attorney and the agent under the Advanced Healthcare Directive is available, is capable, and is able to serve if a crisis occurs. We also want to check the beneficiary designations under things like IRAs and life insurance to make sure they're consistent with the estate plan. So now, had we had a maintenance program back when we set up our planning for Ruth, and had Ruth been a part of that plan, 10 years wouldn't have gone by without us getting together with her. We would have been all up to date, and we wouldn't have had the problem of a power of attorney that was no longer available. One of the things we also want to consider is possibly a Medicaid asset protection trust. We can use that to transfer certain kinds of assets and get them out from under the radar of Medicaid if it appears that Medicaid is going to be needed in the future. One of the things we do in planning is if we have a client, a husband and wife, and let's say the husband's in a nursing home, and we want to make sure all the assets are transferred into the wife's name if she's living at home, and then revise the wife's will so that if she dies before her husband, those assets don't go back to him but go into a special needs trust for him. That way, the quality of care he gets at the nursing home can be enhanced, and at the same time, he doesn't get disqualified from Medicaid if he dies before him. So what we want to do is make sure everything is kept in order, up to date, and kept up to date through a maintenance program. There are some other tips that Lori's going to talk to us now about on preparing.
So Tom and Kim just covered all the important issues that your team of advisors can guide you through and help you with. Now we're going to talk about some of the things that you should do early to prepare for your loved one's possible incapacity. One of the most important things that you can do right away is have a family meeting. Start regular family meetings and start the conversation amongst the family about what matters most in your loved one's life. Include them if it's possible. If not, you can talk to them separately and then relay their responses to the rest of the family. Are they worried that they're going to have to live somewhere else? Are they worried about being alone? Or are they worried about being a burden on the family and want to be cared for somewhere else to reduce the burden on the family? Take some time to explore gently what brings them joy. Maybe it's playing with the dog every day or visiting with the grandkids on Sundays. Maybe it's a trip to Vegas. But find out what matters to them, what brings them joy, and share it with the family, because the more you know about what matters to your loved one, the better you're going to be able to help them. And then, as Thomas said, identify the people that have been chosen to be their medical and financial agents under their power of attorney and advanced healthcare directive. And be sure that those persons understand the responsibility of those roles and that they're willing and well suited to carry out those responsibilities. And then finally, have a frank discussion over who's going to participate in being a caregiver, keeping in mind that every family member can contribute in some way so it doesn't fall entirely on one person's shoulders. If it turns out that It will fall on one person's shoulders. Take some time to explore other options. There are professional caregiver agencies, and I would encourage you to talk to a few of them and perhaps get a part-time caregiver on board to give the primary caregiver a little rest and respite every now and then. For those who don't have family here on the island, who are what we call solo agers, maybe the kids are on the mainland, there are professional fiduciaries that can work with you to make those financial decisions, but you need to find them, interview them, get to know them, let them get to know your loved one so that, and get them assigned a role on your power of attorney so that when you need them, they will be available and they'll know what your loved one's priorities are. And then this is of utmost importance. Create a caregiver backup plan. This is the one thing that we find is most often neglected and puts the loved one, the elderly loved one, in great risk. It is obvious to us, maybe not to all, but one person alone really can't provide 24 hours of care, 7 days a week without a break. It's just not sustainable. It's well documented that full-time caregivers are at high risk of becoming ill and in some cases even dying before the person they're caring for because of the strain, the stress, and the demands of being a caregiver. So take some time to think about a backup plan so that if the primary person becomes ill, there's somebody available to step in and take over and to give the primary caregiver some rest, which they will, no doubt need. And then create a medical inventory. This might be a binder where you include medical records, copies of those summaries of visits from the doctor's appointments. You might want to put a list of all the doctors, the contact information, and the caregivers and their contact information, particularly if it's with an agency. Very important to include a list of medications and dosages, and you might want to include where the pharmacy, where the prescriptions was obtained, what the prescription numbers are, how to contact the pharmacies. Copies of medical insurance cards, both sides, please, should be in your binder. They will become very important if you suddenly have to rush to the emergency room. And as Tom has mentioned, the long-term care insurance. If you get an annual benefit statement on a long-term care insurance policy, keep that in your binder as a reminder that there is money available in this to care for your loved one once the elimination period has been completed and the policy has been triggered. In the same fashion, keep a financial inventory. This is something that our team does for our clients and for our clients' families, but you can do this as well. Get another binder and keep track of your loved one's assets, debts, income, and expenses. You can keep copies of their financial account statements. You can keep a copy of their annual real property tax assessment, copies of credit card statements, a copy of perhaps the mortgage interest, annual mortgage interest, just so that it identifies who the account is with, what the account number is, so that if a financial agent needs to step in, all the information is right there, basically at the fingertips of the person that's going to need it the most. Now, you may think it's unnecessary to take the time to prepare these inventories, but because perhaps you're thinking you have all this information, you know all this information, but consider that you're not bulletproof. that if you should become ill, something should happen to you, the person that will take over for you is going to need to know all this, and they will very much appreciate the fact that you're organized and you've put all this vital information into one place. And then if there is concern that at some point money is going to run out for long-term care and that government assistance may be needed to help pay for future care, then start gathering the types of records and information that are going to be required at that time. Both the Medicaid long-term care program and the VA aid and attendance programs require a lot of documentation. On the Medicaid side, the Medicaid office has the right to go back and look at financial information spanning the last 5 years. That's the famous 5-year look back that everyone knows about. On the VA side, there is now a 3-year look back period. So start assembling these things in advance before you need them, because that will reduce the burden of locating them later when you're ready to apply. These are the sorts of things that you'll be asked to provide: birth certificate, marriage certificate, a death certificate of a spouse, the account statements that we just talked about, Social Security card, and for the VA aid and attendance benefit, the DD-214 military discharge becomes important. If there's digital property or online accounts, such as online banking, social media accounts, even email accounts, make a list of all these accounts and the passwords and the pertinent information that you would need to know, and specify what should be done if your loved one should become incapacitated or after they die. I note that Facebook has actually provided options that can be chosen in advance by the account holder to either remove the account after death or to freeze it as a memorial. Store the information in a very safe place, maybe in your safe deposit box, and make sure that the agent knows how to access it at the appropriate time. So, all of this is going to greatly reduce the family's anxiety and fear. That's one of the biggest benefits of preparing early. And frankly, we consider this an amazing gift for the family as well as for your loved one to do this early and be prepared. You basically help them immeasurably in a potentially challenging and an emotional time. And most importantly, the team of advisors that you have gathered together can then respond immediately in the event of a crisis to help your loved one and the family.
Lori, this might be a good time for me to interject and give the rest of the story about Ruth.
Yes, please.
You remember Ruth? Well, our elder care coordinator went out and visited with her, and she looked over her medications. And she thought, well, I think she's being over-medicated for this epilepsy problem she had had since her youth. So she talked to the PCP, and they redid the medication plan for her. And by the way, nobody had thought about putting batteries in her hearing aid or changing the batteries for her hearing aid. So after they changed the medications, they got batteries in her hearing aid. I then went out and revisited Ruth. And when I visited her, she remembered me. She, well, Tom, it's been many years. Tell me about your daughters. How are they doing? She had cognitive capacity. So we were able to do a new power of attorney. And we were also able to move her to a different assisted living, an ARCH program out in Pearl City, which reduced her cost from $10,000 a month to $6,000 a month. And she was delighted. She fit right in with the other 5 elderly ladies that were there. And so it ended up being a good story. Had we not had the elder care coordinator go out and do this research on her and get her medications changed and updated, it'd have been a totally different story. So that really pointed out to us the value of having a elder care coordinator available and on staff to help with our clients.
Very good
Preparation,
story.
disaster averted.
Yes, and so you're anticipating the hurricane, you're preparing early, and by doing so, you're going to avert a disaster, and most importantly, you're going to be able to maintain more control at a time when you most need it. So our takeaway points are, if you haven't gotten it by now, prepare early. Develop an ongoing relationship with a multidisciplinary team. Start now. Be proactive and not reactive. By being proactive, you have more control and less anxiety.